Well, good morning, everyone. I'm Bob Cooter. I'm the professor of this class. We'll see whether this microphone really is a help or whether I need to turn it off. If anybody can't hear me in the back of the row, make sure you raise your hand. All right, I need to know something about you. How many of you are economics majors? How many of you are legal studies majors? Okay, fine. And now, this course combines law and it combines economics. And I think it's a tremendously exciting class. If you are alert in this class, and you pay attention as you should, and if you are the elite, which is who you're supposed to be, then at the end of this class, you will read the newspaper differently than you've ever read it before. Because you'll think about the law differently than you've ever thought about it before. And the law is pervasive. It's all around us. Now, on B-Space, we have a comprehensive syllabus for you explaining the course. I'm going to go over those items. I'm not distributing it because it's available to everyone. There are two Law and Economics classes, Law and Economics 1 and Law and Economics 2. And Law and Economics 1 is what you're in. Now, Law and Economics 1 concerns private law, and Law and Economics 2 concerns public law. Who in legal studies can tell us what private law is as opposed to public law? Anybody? Nobody can tell us. Oh, come now. You know, it's no fun to have a class if you just sit there in stupor and silence. Nobody can tell us what private law is. Well, tell me this. Suppose you're driving in your car, and you're on the way to campus, and you're concentrating on the really nice music that's coming through your stereo system, and you collide with another student who is also concentrating on the very nice music that's coming through his stereo system on his car. So the two cars have hit. Now, how is liability going to be decided in that case? What's going to determine how much you owe the other guy and how much the other guy owes you? Does anybody know the answer? It has something to do with who is at fault. Come now, you're driving all around in total ignorance of what your liability is. Suppose that you were not at fault. Do you owe the other person anything? No. Suppose that the other person were not at fault. Does he owe you anything? No. You each have to pay your own costs. However, I said that both of you were concentrating on your stereo systems and not on the road, so it's quite likely that you were both at fault. And what happens if you were both at fault? Then what happens? Anybody know? Nobody knows. My goodness me, here you are driving around in total ignorance of something that you will understand very well at the end of this semester. Because the legal doctrine is comparative fault. You will each be liable for the total cost of the accident, which is the sum of your harm and the other party's harm, in proportion to your fault. So if your fault was twice as grievous as his, then you will pay twice as much as he will. The net payment will go from you to him. Okay? That's the rule of comparative fault. Now, where do laws like that come from? Where did we get the law of comparative fault? Come now, students. Come, you know democracy, yes. Where did it come from?
It comes from ideas found in economics that have to do with incentives, so that we have laws that incentivize these kinds of things.
Great stuff. Now, those are the right words for this class. Yes, indeed. That's the way we analyze the rule. But the question I'm asking is, who made the rule? How was the rule made? I mean, you're giving reasons to have it. The reasons have to do with the incentive of parties because we want them to be alert and not listen too much to their stereo systems when they're driving around their cars, right? We want them not to be at fault, so we penalize them when they are at fault by making them liable. But who made the rule? Well, how are laws made in California? By the legislature. The legislature votes it through, and then the governor signs it, right? And that's not how this law was made. This law that affects you every day, the legislature had nothing to do with it. And the governor had nothing to do with it. So where in the world did the law come from? Now, somebody in legal studies must know the answer to that. Judges. Judges made the law. And when judges make the law, what kind of law is that? What is it called? The common law. It's the common law. Judges made the law. One day there was a case called Lee versus Yellow Cab, which involved exactly an automobile accident. And the California Supreme Court said from now on the rule is comparative fault. It's comparative fault. Didn't used to be. It used to be another rule called negligence with a defense of the contributory negligence. You'll learn about that. However, the court just changed the law because most of the law of accidents is common law. It's not made by the legislature. Isn't that interesting? I wonder how many Americans understand that many of the laws that they're subject to were never made by their democratically elected representatives, nor were they made by judges interpreting the Constitution. We've just had one of the most important constitutional cases, probably in 20 years. The case that decided that Obamacare is constitutional. Obamacare is called the Affordable Care Act, the ACA, and the Supreme Court of the United States decided a couple weeks ago that it was constitutional. This is a tremendous event. This is the courts making the law through interpretation of the Constitution. However, with the common law, the courts aren't even interpreting the Constitution. They're just making it up completely. They're making it up completely based upon some views they have about what's right, about what's fair, and what the consequences are. Suppose that you sign a contract. When you came to the University of California, you probably signed some kind of contract, right? Did you sign a contract? Did you agree to pay them something and they agreed to teach you or something like that? Oh, that's right. Well, let's keep that contract. You're supposed to learn, I'm supposed to teach. Let's make sure we keep that contract. Now, suppose this contract had to be adjudicated. Suppose you dropped out of school early and you felt that you shouldn't get back your money that you paid for the semester, and the university felt otherwise, and there was a law case about it. How would that be decided? Would that be decided according to rules set by the legislature or according to rules set by the court? According to the common law or according to statutes? Hard to say. Probably a combination of both, but mostly common law. The law of accidents, which is called the law of torts, and the law of contracts, much of it is common law. There you go. You see, you've learned something already. And without really trying, right? Now, next time you got to try harder. Because I want to explain to you something about the way we teach in a law school. You're not in a law school, but you're going to be taught a little bit as if you were. Now, how many people have read anything by Socrates? Any Socratic dialogue? What did you read, sir? Do you remember? Asking a lot of questions, right. Socrates asked questions. So he asked questions in order to teach, right? Now, why did he ask questions instead of just lecturing to people? Isn't the point that I should lecture to you and you should write it down, yes?
Audience engagement keeps you more alert, more interaction, so you learn more from it.
That's right. In law and economics, as in all of law, learning is the struggle to articulation. It's the struggle to be able to say it. If you can't say it, you don't understand it. And you don't get to say it by listening. You get to say it by speaking. That's how you learn to say it. Can you imagine learning French by listening only and never trying to speak? Well, it's like that with law and economics, only even harder because it's all the concepts have to be analyzed. And you analyze them by speaking. So Socrates understood this. He understood that learning is not like taking a pitcher and pouring milk into a glass. I'm not pouring information into you. You are struggling to articulate the concepts in this class. That's what you must do. That's why the exams, we have a midterm exam, we have a final exam, and we have quizzes. And they are all open book, open note. And if you can find the answer by looking in your notes and writing it down, if that's the way you approach the exams, you're in trouble. If you have to extensively consult your notes, you're not going to do well in this class. Because you've got to be able to articulate it. You've got to be able to say it, not find it in your notes. Okay. Now here's a note that I want everybody to take down, okay? Everybody write this down. In this class, in lecture, you do not need to take notes. Okay? That's your final note in this class. In this class, you do not need to take notes because everything important is in the book. I can assure you that. I wrote it. Everything important is in the book. And everything important in the book is set out in a way that's very clear, I hope. It's certainly very logical. If you want to take notes on the book. Because taking notes is part of the struggle to articulate. Identify the key concepts, pull them out of the book, try to think about the propositions and see if you can start to speak the language. But in class, you don't need to take notes, you need to struggle to articulate. You need to try to understand what I'm saying. You need to say it to yourself as I'm saying it. And you need to ask me questions. Now, it'd be nice if there were only 2 of us, then we would do the Socratic dialogue full force. If there were 10 of us, I could do it much better. If there were a class this size and you were all law students, I could do it to you because there's a way that we make you do it. And that's this. In law school, I keep a class list. And I know all your names on the list. And sometime during the course of the semester, you're going to get called upon. And when you're called upon, you have to stand up and engage in a Socratic dialogue with me. And when you engage in a Socratic dialogue with me, I don't just ask you one question, I ask you a series of questions. Furthermore, I write a little number in my book after you're finished. So as a consequence, law students come to class very alert. They're prepared. They've read the material in advance, and they struggle with it. And then we teach Socratically. That was the old way. It's still often done. A substantial amount of that is still done, and it's a great way to learn. I know from experience I can't do that with you people. I know what happens with you people, which is I end up having a dialogue with about 5 of you. This is not good. Remember, the question that seems so stupid, you think it's too stupid to ask, that's the question that everybody in the class wants you to ask, because they don't get it either. And if you don't talk up and you don't raise your hand, the class is going to be hard. It's going to be hard for me to know what you're not getting. So we got to try to have an active class in here, all right? Now, I've told you that there was a difference between private and public law. And we started out talking about common law, which is an example of private law. And the characteristic of private law is this. In private law, the plaintiff and the defendant, the 2 parties in the legal case, are usually, ideally, both private persons. I sue you. I sue General Motors. My insurance company sues me. That's all private law. That's not like in a criminal case, because in a criminal case, the plaintiff is called a prosecutor, and the prosecutor is a state official. I cannot prosecute another private citizen for burglarizing my house, for raping me, for assaulting me, for running into, for any crime. You used to be able to do that. In the 17th century in England, the prosecutor was the victim. That's not true anymore. Now the victim is not allowed to prosecute. So, when there's a crime, the prosecutor is a public official and the defendant is usually a private person. That's public law. Sort of public law. Now, public law, in its purest case, is where you have big government agencies involved. Like you have regulations being adjudicated. The ACA, Obamacare, is going to lead to untold numbers of lawsuits. And in those lawsuits, the government will be a party. The government will be defending itself. The government will be trying to make an insurance company do something. And those disputes all involve public law. So what are the subjects of private law? First of all, we've been talking about accidents. And the private law of accidents is generally called torts. Or rather, accidents is most of the law of torts, but not all of it. Now, tort is is a funny word, right? It's a funny word. Maybe you think it's something made out of chocolate with a lot of cream. Well, where tort comes from is this. Tort is a strange term called law French. And the reason we have words like tort in the law is because the Norman French conquered England in 1066. The last time England was conquered by a foreign country, by a foreign power, it was the Norman French speakers from Normandy. And they imposed their monarchy in a legal order there. And the law is very slow to change. The legal terms are very slow to change. So the legal terminology still has a lot of law French words in it, and tort is one of them. So tort is a law French term. That's why it's kind of odd. Now, third area is contracts, which I also mentioned. And what I didn't mention to you is the first area is property law. Property law, right? That's like when somebody plants a redwood tree in their backyard in Berkeley, and they're downhill, and you're immediately uphill from them, and after 20 years, you start to no longer be able to see the Golden Gate Bridge. The Golden Gate Bridge begins to disappear behind those lovely green what are those green things on a redwood tree? They're not leaves. What are they? Who knows? Want to tell me? You're not going to even help me with that? Well, anyway, it disappears behind the greenery, and you're upset about it, so you sue. And you say, look, you have taken my view. I'm entitled to this view, and you have taken it. And that's a suit in property law between two property owners that will have to be decided in the courts. Now, all three of these areas start with common law. One of the characteristics about common law is you can change the common law by a statute if the legislature acts. So I told you that if you run into somebody in your car coming to the campus, the rule under which damages are going to be allocated is comparative negligence or comparative fault. I told you that, right? And I told you that judges made it up in Lee versus Yellow Cab. The legislature could change it at any time, because if the legislature enacts a statute, the legislature preempts the judges. The statute preempts the common law. So if the legislature were to say, no, we're not going to have this rule of comparative negligence. We're going to have a rule of simple negligence. And each person is liable for the negligence that he caused, regardless of what the other person did. That's going to be the rule. Then that would be the rule. So what you have is property, the law of property, the law of accidents or torts, the law of contracts. They're all heavily common law, except where the legislature has stepped in and enacted statutes. So they're a combination of the common law and the statutes, and we'll be studying the fundamental rules. So this is private law.
And we're also going to study the legal process by which these disputes, these private disputes in these areas of law are decided. We're going to study the way the plaintiff, the defendant, the lawyers, the judge, the jury, the way they all interact in private disputes. And finally, we're going to also do crime. And crime is something in between public and private law because it started out private law and became public law. It still fits our models very well. So that's the subject matter that we're going to study here. And if you take Law and Economics 2, which is Legal Studies 147, then you will study public law. Not this, constitutional law, administrative law, regulations, all the laws that the government has created in which it is a party to the dispute. Okay. Any questions about that? Now you see, you're already going to notice something, which is some of you are legal studies majors and some of you are economics majors. And all this stuff that I've been saying so far, all that, many of the legal studies majors understand that already. And most of the economists don't at all. Most of the economists never heard of private law. What does that have to do with courts? What's that anyway? Okay. Well, the economists, you're going to get even because when we start doing the models, they're going to be easy for you. But everybody in this class needs to know something about law or something about economics in order to succeed. Now, the materials for this class are entirely the book Cooter and Mueller, the 6th edition. Now, one of the things about this book is it is unconscionably expensive. And for that, I apologize. If it were up to me, I'd give it away. But I wrote the first edition of this book before there was an internet. And I signed contracts that I deeply regret. And one of the consequences, I can't get the book away from the publisher. The publisher is only interested in making money. I'm not interested in making money. That's not what my life's about. But that's what the publisher's life is about. And that's why it's so unconscionably expensive. Now, unfortunately for you, when I update the book, I change it a lot and improve it a lot. I don't just change it in order to sell copies so you can't use the old edition. It's really, the 6th edition is quite a bit better than the 5th edition. So don't use the 5th edition. Now, if you can find some way to copy the 6th edition from somebody else, well, let's just say I'm not going to be prosecuting you, okay? If you can find some way to avoid paying that publisher's price, I don't mind. The publisher minds. Don't tell the publisher. But I don't mind. However, don't use the 5th edition. That would be a mistake. It's cheap, but it's different. There will be a midterm and there will be a final. And if you look online in vSpace, I have the class sessions, what material that we'll be covering by date. And this is a tentative schedule. I can assure you of one thing, and that is that it will change. It will not be, but for now, the midterm exam is scheduled for October 25th. That could move forward or back the class meeting. And the final exam, of course, that's fixed for December 11th. That's when it will be. As I've told you, this is open book and open notes. There will also be some quizzes, some 10-minute quizzes at the beginning of lecture in the course of the semester. And I have a simple rule to keep things easy and clear, and that is that the quizzes, which count for 10% cumulatively, will be graded with your worst one thrown away.
including your absence. If you miss class or you do terribly, you get a 0, that doesn't count. Okay? That's the way I do it. It simplifies life for everyone. Now, there are sample exams on the web. I'm not sure whether they're there yet. Do you know, Diego? Do you know if they're there yet? No. Not yet. Okay. Well, they will be posted, and you should use those sample exams to prepare. I don't know if I have any sample quizzes. I'll take a look and see. All right. Sometimes there are some questions about enrollment in the class, and Telebears has a system of priorities that are supposed to be fair to everyone, and so I don't respond to individual appeals. I used to do it in the past, and I always do an injustice to someone else when I help out someone who is appealing. So if there's any issues about getting into the class, you'll have to deal with Telebears. People who didn't come to class today, don't come to class for the first couple sessions, are not going to be removed from the rolls. There'll be a couple weeks before we clean it up. Now, one of the wonderful things about Berkeley is that everybody's smart here, and our graduate students are really smart. And I have two teaching assistants, one of whom is not here today, I think. Right? Oh, he came in. Good. Okay. Good. So I've got two teaching assistants here today. One is Mr. Phillips, and the other is Mr. Pardo. And they're both students of mine, and they're both terrific, and I think you're going to like them. Why don't you each stand up and say a little bit about, just a few words about yourself.
James Phillips, I'm a fourth-year PhD student in the Bureau of Social Policy program, which is undergraduate English studies, and this is one of my mentors.
A little louder, Diego.
Okay. I'm in my third year at the Institute of Philosophy, and this is very helpful for my teacher and
Diego is from Chile. One of the great things about law and about the economic analysis of law that's different from law is that the economic analysis stays the same when you cross a border. See, when you go from Peru to Chile, you have somewhat different laws, but the economic analysis is the same. So the economic analysis is a kind of international language for understanding the law, and one of the wonderful things about having foreign students here, we have many, is that they provide interesting data, I would say, about the differences in legal systems. So I think that's particularly glad that Diego is here, and I trust that we have quite a few foreign students here as well. Okay, I think that's all I wanted to say about the organization of the class. Are there any questions? Yes.
If we purchase the textbook from Amazon in the Kindle version, are we allowed to use our Kindle? I bought it before I read the syllabus. Even though the Kindle has like wireless speakers.
Oh gosh, I never thought of that issue. I have no objection to your. Here's the problem. Okay, the rule in the exams I always said was open book, open note, closed mouth. So the problem is I don't really want students emailing each other during the exam. That is unfair because a lot of the questions on this exam, unlike many law courses, are not essays. They're exact answers or they're short answers. They're short, a few sentences. And that means that you can in fact communicate an answer for a question to some student who doesn't know the answer, and they can get it right even though they have no idea why it's right. And so that's the rub. And I never thought about that problem. Do you know? Have you ever heard?
The browser is really slow, and legitimately, the keyboard keyboard is really awkward to use. I think it would be noticeable if someone was...
Oh, I see. You're going to take your Kindle. You're not going to take a laptop? You're going to read it on a Kindle?
Yeah.
Pardon me?
Yes.
Okay, that's fine. No problem. That's all right. If you want to read it, I read Kindle books on my computer and on my iPhone. If you wanted to read it on your computer, that would be a bit of a problem. Yeah, that's good. I hope. Is it more reasonable? How much is it on there?
It's more than renting it, I believe, but much less than buying it.
Well, good. Great. Glad to hear it. Yeah.
I know you said it's not as important to look at notes during the class.
Yeah.
If you bought the digital copy, how would that affect me bringing a laptop to midterm or exam?
Well, you mean if you bought a digital copy you bought the Kindle book and you wanted to bring it? Well, you see, I don't know the answer because I never was confronted with that before. My concern is that you not be able to email others. If we had a system here that shut off the internet for the room, then I would be happy with everybody bringing their computers. I wouldn't mind at all. But so I'm sorry. I don't really. I'm going to have to consult with somebody who knows. Yeah. I really would like for you to be able to use the electronic copy because that's the way the world should go, and that's the way things will get cheaper. Yes.
You said you were going to go into the
Yeah.
one of those?
One of them. Yeah. One of them. So that'll probably be like 5 or 6 quizzes. Yeah. Anybody else? Yes, please. Pardon me?
The quizzes, are they going to be administered during lecture?
In lecture. Yeah, first 10 minutes of lecture. That's also a reason to get the lecture on time. Okay? Anybody else? Yeah.
Is section meeting today?
No. When you guys want to tell them when your sections are going to meet? Do you know?
I believe it's next week section starts, so
Yeah.
nothing this week.
Yes.
Sorry, is it like the first 10 minutes after birthday time, or
What? Pardon me?
is it the first 10 minutes after birthday time that the quizzes are going to be, or is it?
When's Berkeley time? What? Go ahead. What?
It's like 10 minutes after the class is supposed to start, so we'll go back to that class.
Yeah, I didn't know that. Okay, so I get confused. When I first came here, when I first came here, I had an 8 o'clock class, and I was lecturing. I was doing my lectures, and finally, after 2 weeks, one of the students said, "Why do you always start early and end early?" Because I thought 9:30 classes started at 9:30, but they don't. All right. Law school has a different system. Okay, then everything will start at 9:40 if that's the way we do it. Yeah. Okay. All right. So let's then talk about what law and economics is. Chapter 1. Now, philosophers often start a class or a subject with a question. What is an X? For example, Socrates asked the question, what is a man? What is a man? We would today say, what is a person? What is a person? And what he was looking for were some criteria that would define what a person is. And in the end, after a lot of dialogue, he decides that a person is a rational animal. If it's rational but it's not an animal, then it's not a person. It's maybe a machine. If it's animal but not rational, then it's not a person. Maybe it's a dog. But if it's rational and it's an animal, then it's a person. And from that, he draws things of great significance. Because he thinks that being a person, combining rationality and animality, is decisive in our character and the things that we ought to be doing in life. Now that's a really nice way to start a subject. So, in a similar spirit, we could ask, what is law and economics? What is it? Well, I'm going to give you some suggestions, some answers to that question. And later on, as the course develops, I'm going to explain to you why the method of Socrates doesn't work so well in modern law. Now, one of the characteristics about law and economics is this. After 1980, law and economics exploded in terms of its role in law schools and in universities. We track the growth of a subject these days partly by counting footnotes. You count footnotes, and one of the studies counted footnotes to law and economics papers. And in a few years after 1980, there was a 300-fold increase. It's really explosive growth. And I experienced that. Let me give you a word of advice. When you go out to get a job, try to get a job in an expanding industry and not a declining industry. It makes such a difference. I came to the University of California in public finance in the economics department in 1975, and by 1980 I had switched to law and economics. And I was the first person to teach law and economics on the Berkeley campus, first person to research the subject. There are now 8 economics PhDs on the law faculty at Berkeley. And there's also law and economics in the economics department, the business school, and the public policy school. So I experienced that explosion in the subject, and my career benefited a great deal from it. Kind of like this. If you were a mediocre farmer in Normandy in 1750, and you could get yourself over to New York, you might get rich. You were never going to get rich in Normandy, but you might get rich in New York if you arrived there in 1750 and were a reasonably competent farmer. And that's what can happen to you when you get into an explosive growth, a field with explosive growth. So I've had a delightful career. Now, yes, it's wonderful. I travel around the world and give lectures and have friends all over. And now I'm a senior scholar, they say. I'm a senior scholar. Now, you know what a senior scholar is in law and economics? A senior scholar is somebody who can remember its history. I don't have to read the history of law and economics. I lived it, and I remember it. And as a consequence, you're going to be subjected to some of my reminiscences. Ah, yes, back in 1980, before we had the computer, blah, blah, blah. Okay, that's the way you have a certain amount of that, because historical perspective on a subject is useful. Now, after 1980, law and economics exploded. Why? Well, the way I would explain it is this. It's like the rabbit in Australia. You see, when the rabbit got to Australia, its numbers exploded. And it was a real pest. Somebody introduced the rabbit because he thought hunting rabbit was a pretty good thing to do in England, and it might be a good thing to do in Australia. But what he didn't understand was the rabbits were going to explode in number beyond all reason. And the farmers shot them, and the farmers gassed them, and the farmers trapped them, but they just couldn't kill the rabbits because the rabbits had found a hole in the ecology that they were wonderfully equipped to fill. And that's what happened to us. We law and economics scholars found a hole in the ecology of ideas, and the senior professors hated us. Many of them did. They trapped us, they gassed us. No, they didn't actually do that, but it felt that way. It felt that way. There was a lot of hostility to this subject. There still is. How many know the name Richard Posner, probably the most famous law and economics scholar? A few people. Well, he is famous and he is detested. Still a controversial subject. Now, we know, as a matter of fact, that law and economics exploded. And after 1980, it exploded because it found a hole in the ecology of ideas. So,
If we want to understand what law and economics is, one of the things we should try to understand is what was the hole in the ecology that it filled. What was the vacancy? It was just waiting for something analogous to the rabbit to appear. This happens sometimes in the history of the world. For example, I used to go to a town in Belgium to sit on the town square and drink beer. Yes, I've been known to drink beer. And sitting on the plaza there, having a Belgian beer with my Belgian friends, there was a very nice clock tower you could look at. And this clock tower was about 3 stories high, windowless, had a number of clock faces on it. And what was remarkable about it was you could tell it had 3 different clock faces. So you could have time in 3 different places. And this was important in Belgium in the late medieval period because every town was on different time. If you were a merchant, you wanted to go from one town to another, you could sit on that town square and look up and see what time it was in another town you were going to visit. This was like a miracle, right? Now, over centuries, the wheels in that tower got smaller and smaller. And eventually, they got so small, you could put it on your wrist and wear it and look at it and see what time it was. But no matter how long people worked making those wheels smaller and smaller, they would have never invented the quartz watch. The quartz watch had to come from somewhere else, from a different technology. The tradition, the trajectory of the tradition of watchmaking did not lead to the quartz watch. It's completely different. And that's what happened with law and economics. You see, people have always wondered what the effect of a law would be. Right? A law, many laws, not all, but many laws, consist in an obligation backed by a sanction. For example, the obligation to pay attention when you're driving. If you fail to pay attention when you're driving and you have an accident, then you're at fault and your sanction will be liability. If you fail to pay attention when you're driving and you exceed the speed limit, you have a lapse, the sanction may be a speeding ticket. But many laws consist of an obligation backed by a sanction. Now, one of the things that people have always wondered about is what would be the effect of changing the sanction? You just imagine Romans sitting around the forum in their togas in the year 10. And they're saying, you know, there are too many drunken youths racing their chariots up and down the Corso. Understand we had a little problem with a chariot running into a dormitory at Cal recently. Is that right? That's what I heard about, yes. Some youth was racing his chariot and ran into a dormitory at Cal at 3 in the morning recently. Now, I'm sure they had these problems sitting around the Roman Forum. And so somebody said, well, look, what we ought to do is this. The penalty for racing your chariot through the Corso is 2 drachmas. Let's make it 4 drachmas. I don't have any idea what a drachma is either. So I don't know what was the Roman unit of currency. Does anybody know? What? Denarius? Oh, really? What?
I think Sesterti was the other one.
The Serti?
Yeah.
Oh, well, I don't know. Okay, all right. Well, which is bigger?
The Denarius.
Denarius. Okay, 2 denariuses. The penalty was 2 denariuses. All right? Thank you very much. And so somebody says, well, look, let's make it 4 denarius. We'll make the penalty 4 denarius. Are people is that going to deal with the problem? What's going to be the consequence? And some people would say, well, you know, I think 4 denarius is a lot of money to these young guys. Guys, you know, it's always guys, by the way.
Just look at insurance rates if you don't believe it's only that. It's nothing else. That's true, you know. My daughter was a more reckless driver than my son, but when they both had a car, I had to pay more than twice as much for my son's insurance. This is common, you know. Young men are just not very careful. So, when you get in your car with your girlfriend next time, go, just move over and let her drive. All right, okay, so these young men are racing through the up and down the Corso, and the senators are sitting talking about what to do about it, and one of them says, let's double the fine. And somebody says, well, I think that'll make a big difference. That's a lot of money to these people. They're going to pay attention to it. And somebody else says, I don't think they will. They're often drunk. They're not rational. They're not calculating. They live in the eternal present. They do not know about the future. If you double the penalty, that's going to be meaningless to them. They're not going to slow down at all. Now, this is an empirical question. You might get a big effect. You might get a small effect. And the way it was decided for 2,000 years was by intuition. Let's see, if I were a young person, no, you can do a lot better than that. You can do a lot better than that. Because in law, the question of whether a higher penalty, a higher sanction, will cause more conformity to the obligation. Question whether a higher sanction will cause more conformity to the obligation is called the deterrence hypothesis. It's the hypothesis that the sanction will deter violations of the obligation. And the deterrence hypothesis that if you increase the sanction, you will increase the amount of conformity to the obligation, corresponds exactly to what is probably the first or one of the first things that you learn in economics. Because one of the first things that you learn in economics is that the demand curve slopes up. And I made a mistake there. You see, that's to keep you alert. You all know that the demand curve does not slope up. It slopes down. When you raise the price, people buy less of the good, not more of the good. Right? The demand curve slopes down. As a matter of fact, sometimes that's given the illustrious name, the first law of demand, the proposition that the demand curve slopes down. So, what the senators were debating when they were discussing whether they should double the fine for racing chariots up and down the Corso was the elasticity of the demand curve. That's what they were debating. They were saying, is the demand curve elastic or is it inelastic? If we change the price, if we increase the price of speeding, that's the way an economist would put it, if we increase the price of speeding, where the price is a legal price, it's a legal sanction, if we increase the price of speeding, how much will the reduction in speeding be? If demand is highly elastic, we'll get a big response. If it's inelastic, we'll get a small response. Now, there's a big change from deterrence as it was discussed for 2,000 years and the elasticity of the demand. It's roughly the change from wheels to quartz crystals. Because the technology for estimating demand curves is very sophisticated and very well developed. We have microeconomic theory for reasoning about demand and predicting whether you'll have high or low elasticity. The main result of that, as you all know, is the closeness of substitutes. If there's close
substitutes, demand will be highly elastic. If there are few substitutes, only remote substitutes, demand will be inelastic. And where there are no substitutes, we say the good is a necessity. So the theory of demand has been worked out. And in addition to the theory being worked out, it's also the case that the econometrics has been worked out. The econometrics for estimating the demand curve. Which brings to mind this fact. I was not scheduled to teach this class. I'm teaching it for someone else who is a superb econometrician. And because I took his class, I have a few conflicts, and he's going to come in and teach a few of the classes, and his name is Justin McCrary. Justin McCrary is another economics PhD in law school, and he's an econometrician, and he's really good. So you can look forward to finding out how you actually estimate things, like demand curves, in the law from Justin. So we get this big change in technology, and suddenly it's possible to think scientifically about the consequences of the law, about the consequences of attaching a sanction to an obligation, how that will change behavior suddenly becomes amenable to scientific inquiry. And that is a big hole in the ecology. You spend 2,000 years making predictions based on intuition, and suddenly you get a mathematical theory and statistical techniques that go far beyond intuition, and that is a revolution in the way a subject is conducted. So, that was the hole in the ecology, and of course the traditional lawyers hated it. They hated it because they didn't know how to do mathematical models, and they didn't know how to do econometrics. And people don't like to feel inadequate, especially when they are famous and make more money than you do. They don't like to feel inadequate, so there was a lot of hostility to the subject. Now, there's also hostility to the subject for other reasons, and it has to do with this fact. In economics, we often make predictions of the kind, how elastic is the demand curve? For example, when there was an Arab boycott of the U.S. with respect to oil in the 1970s. And the Arab oil boycott caused the price of gasoline to increase enormously in the U.S. And naturally, at that point, people made a lot of predictions about what the effect would be on the consumption of gasoline, particularly by automobiles. So people wanted to know, would there be more or less? How much more? How much less? However, there's another question that economists often ask about prices, and that is not whether an increase in a price will lead to more or less of the behavior, but the question of, will the change be efficient or inefficient? Right? I mean, you could ask this question. Suppose somebody's racing down the Corso with his chariot because he's really in a big hurry. And his time is very valuable. He has to get to the forum to close an important business deal. Or even more compelling, he has to get his passenger to the doctor. So he's in a big hurry. And if we sharply sanction him for going fast like that, then people in his circumstances are often going to slow down. So we have to ask ourselves, if we slow the traffic down, we have fewer accidents, which is a benefit, but we also spend more time commuting, which is a cost. So we want to know not just whether doubling the fine from 2 to 4, what is it? Denarius. From 2 to 4 denarius, doubling the fine from 2 to 4 denarius, we want to know not just whether people are going to slow down a lot, but whether it's going to be more efficient or less efficient. Whether the gain in lower accidents is going to be worth the increase in the cost of time traveling. Now, Predictions about efficiency. That's a prediction about efficiency. Predictions about efficiency are very controversial because efficiency is an important value, but it's not a value that judges have traditionally talked about. Judges don't talk about efficiency. They talk about what? What's the value of equivalent generality to efficiency that judges talk about all the time? Well, come on, when they talk about justice, right? Say, is this just? Is this fair? So when economists said, look, in fact, a lot of questions of justice can be resolved into questions of efficiency, you can imagine the controversy that created. Great deal of controversy. What do you mean? It would never be, the judges should never do what's unfair because it's just because it's more efficient. They should always do what's fair without regard to what's efficient. People said things like that. Said, no, that's not the claim. The claim is that what they mean by fairness here is usually efficient. All right, so that's a big issue. The predictions that you can make with economic analysis is not just predictions of more or less. It's not just the elasticity of the demand curve. It's not just the deterrence effect. It's also the question of the efficiency of the effect. So we're going to have a lot of models where we look at the efficiency of laws. For example, I told you that California changed its previous law on automobile accidents and adopted the law of comparative negligence. Now, one of the things you'd like to know is, was that more efficient or less efficient than the previous law? Well, I'm going to show you how to find that out. And that's one of the reasons, at the end of this course, if you're smart and you take to it, you're going to read the newspaper differently. If when you read the newspaper, instead of just asking whether this law is fair, you're going to ask what are its effects on behavior, and are those effects efficient or inefficient? New way of thinking about the law and policy. Now, efficiency is a value. It's a value in this sense. When somebody says A is more efficient than B, they're never making an argument to adopt B. Okay? That's not a reason to adopt B. So you have a choice between A and B. Why are you going to choose B? Well, we should choose B because it's less efficient. That doesn't make sense. Right? Efficiency always counts in a positive direction because waste is bad. And economics is about wasting money, and wasting money is, nobody favors wasting money, at least not in public. Nobody stands up in public and says, let's waste money. Lots of politicians like to waste money, but they don't say that that's what they're doing. So, efficiency is a value. I'd say it's a policy value. There are certain policy values that are very important in the law, and one of them is efficiency. Now, there's one other value that's very important in the law, and that is also important in economics. Economists are experts on the value of efficiency, and there's another value that they're experts on, and what is that? What? Yeah. It is distribution. Very good. Okay. Because from the beginning, when people sat around the forum and asked whether they should double the fine on youth speeding, racing their chariots, people were not just interested in the efficiency, whether the savings in accidents was greater than the loss in additional travel time, and they were also interested in who bore those effects. For example, probably most citizens in Rome could not afford a chariot. Probably those youth racing those chariots were the kind of people today who come to Cal in a BMW. They've got a little money. They've got a little money that a lot of other people don't have. So one of the debates would be, well, should we impose this higher cost on this class of people. And that distributional question is a kind of question that is raised repeatedly in the history of economic analysis. One of the first uses of economic policy, one of the first uses of economic analysis in a big policy debate in England concerned the repeal of the tariff on wheat. Wheat in England is called corn, so it's called repeal of the corn laws. And the tariff on wheat kept out cheap wheat from Canada, the U.S., and Argentina, places like that. And repealing the tariff on wheat had big effects on the class system in England. And so economists debated such questions as how would this change affect agricultural workers versus the owners of agricultural estates? How would it affect industrial workers and the middle class in the cities as opposed to people in the countryside? These are all distributive questions. Okay? So economists are expert on both efficiency and distribution, and they make models that predict what the consequences of the law will be for not only natural values like faster or slower, but also normative values like efficiency and distribution. Now, there is a big difference between the way economists talk about efficiency and the way they talk about distribution, and what's that? Well, economists all take a position on efficiency, right? And we're all in favor of it. Everybody's in favor of it. The fact that A is more efficient than B is a reason to adopt A. It's not a reason to adopt B, right? What about distribution? Yeah, it's a lot of disagreement, right? A lot of disagreement because, first of all, most people think that economic equality has some value. But how valuable it is much in dispute. The extent to which we should redistribute money directly or intentionally from one class to another, how much should we do that? That is a very big issue. And we all understand that the Democratic and the Republican parties have somewhat different views on that matter. Right? So, because distribution is controversial, many economists do not take a position on how much equality is the right amount. And others do. Some economists feel perfectly comfortable in their role as economists, arguing for a particular distribution, and others do not. They simply parameterize the effects, predict what they will be, the distributive effects on different classes, but do not advocate anything. All right, these are the two big values, the two big policy values that are important in line economics. However, we are studying private law. And in private law, in the study of private law, there's a reason why we talk almost exclusively, not completely, but almost exclusively about efficiency and not distribution. Can anybody see what that reason might be? Yeah.
Well, in your reading, it talks about how addressing distributive issues through private law isn't an efficient way to address it, so it's really a public law issue. So that's why it makes more sense to address efficiency only, or efficiency mainly. Right?
That's exactly right. And I like to use this metaphor. Suppose that there are two oases in the Sahara Desert. And one oasis has ice cream, and the other oasis has no ice cream. So the people who live in the oasis with ice cream say, we should really redistribute some ice cream. We should share our ice cream with those people at that other oasis. So they fill up a bowl with ice cream,
to send over to the other oasis. Now, should they choose to carry it, the slim, gazelle, speedy youth, or the rather overweight, slow-moving youth? Which one should they choose? Well, clearly, it's important to get that ice cream across the desert fast because some of it's going to melt, right? That's what happens with redistribution. When you redistribute, there's usually a cost. Something gets used up. Sometimes it's a little, and sometimes it's a lot. Many of you, no doubt, get telephone calls, as I do at dinner time, by people asking me to give them money. Now, there happens to be a website called Charity Navigator, and if you actually care enough to get interested in the person who's calling you should look on Charity Navigator because it tells you what the overheads are. And there are some charities who spend almost 100% of what they collect on salaries. They're just machines for employing the people who are making the telephone call to you. That's like having the slowest kid carry the ice cream, most of which melts. You send the ice cream across the desert, right? Maybe a better analogy would be you send the ice cream across the desert, and the kid gets halfway across, sits down, and eats it. That's what happens with those people who are calling you on the telephone mostly at the dinner time. And there's some, by the way, charity. By the way, you have an obligation to charity. That's really important. You need to give money to others because you're privileged. You're privileged even now, most of you. In the Judeo-Christian tradition, you're supposed to give 10%. Hardly anybody does that. We're much richer than our ancestors, and we don't give much money away. My dad gave 10% of his income away every year, and he didn't have nearly as much as I did. So it's very important to be charitable, to redistribute to others, and when you do it right. Don't give it to some organization that eats up 90% of what it takes in. Give it to someone who distributes it efficiently. So redistribution is important. I care a lot about redistribution, but I want it done efficiently. The concept of efficiency applies to distribution itself. And if redistribution is inefficient, you should choose another means. So the reason why we're going to talk about efficiency in this class mostly and not distribution is because private law is an extremely inefficient way to redistribute wealth. That's not hard to understand. Suppose you're listening to television and you see some ad from a law firm that's looking for people who are victims of something. All right? And you didn't breathe asbestos, but people who are my age, people who are my age who did. And the latency period is like 30 years. Afterwards, they're likely to have gotten lung cancer. And so there are lots of tort lawyers who are looking for people like that to bring suit, to represent them in a suit against whoever it was who put them in the position that they breathed asbestos dust. Now, there's a standard amount of money that such a lawyer charges, which is a percent of the claim, percent of the recovery, usually. So if he recovers 100, then there's a standard contingency fee, it's called. It's called a contingency fee because the lawyer only gets paid if he wins. So under the contingency that he wins, he gets paid a fee, and he usually gets paid a percent. So if he wins 100, what percent does he usually get? Does anybody know? Yeah, 30. That's the standard. That's right. So usually it's 30. So 30% is a standard contingency fee. That's for the plaintiff's attorney. Now, what do you think it costs to defend in these cases? Well, what it costs to defend in these cases is usually at least as much as what it costs the plaintiff to bring the case.
So if the stakes are 100, the plaintiff's attorney is taking 30%, and the defendant's attorney is taking at least that much. So that means what? 60% of the money has been burned up in legal fees. That's like a kid sitting down in the desert and eating the ice cream. That's not redistributing to anybody but lawyers. That's why the private law is a poor instrument of redistribution, because it's so inefficient. It wastes so much. If you're going to redistribute income, you should have an efficient policy that doesn't take a large percentage of the money and burn it up like you do in litigation. And there's something else as well. And that is that a legal system in which the judges weight the scales of justice in a property dispute or an accident or a contract according to how much money the parties have according to how much money the plaintiff and defendant have, is a legal system that's going to be fraught with problems. Can you imagine? How would you feel if you were involved in an automobile accident and the judge said to you, well, I've got to decide who's liable for how much. Now, it's really important for me to decide who's liable for how much, to know how much money you make. Tell me what your salaries are, because I'm going to make sure that the person who's liable is the person who has a higher salary. Would you like to live in a world like that? I would not. And where it really gets to be a problem is when you can make contracts. Because if a contract dispute is going to be decided by the judge tipping the scales for the poorer party, then in that case, when you sign a contract, always try to contract with somebody who's richer than you. If you contract with somebody who's richer than you, then the scales are going to be tipped in your favor if there's a dispute. And if you sign a contract with somebody who's poorer than you, then the scales are going to be tipped against you. So as a consequence, if you allow the scales of justice to be tipped according to the wealth of the parties because you're trying to redistribute income, the consequence is you disable people from making contracts with those who are richer than themselves, because the richer people don't want a contract, don't want to do it. Now this can be really serious. For example, many of you may have seen in the papers on some occasion a story where Brazilian peasants seized land and occupied it. You may have read that in the paper. This happens in Brazil. And one of the reasons it happens in Brazil is because if you are a Brazilian peasant, you can't borrow money to buy land. You can't borrow money to build a house. And the reason you can't borrow money to buy land or to build a house is because the courts will enforce a dispute over that mortgage in favor of you and against the lender, because the lender is some rich bank and you're a poor peasant. So rich banks won't lend you money for a for a house or land, and that's why, one of the reasons why peasants seize the land, because they can't get it in another way. Can you imagine what would change in the U.S. in our housing if all homeowners were favored by the courts against the banks, so that as a consequence, if the banks lent you money and you didn't pay them back, they couldn't repossess your property? Nobody's going to lend money for a mortgage under those circumstances. We're involved in that right now, aren't we? We had all this chicanery and wrongdoing where a lot of money was lent to people who couldn't actually, who were poorly situated to pay back their loans, particularly poor people. And now they're being foreclosed upon. And naturally, your sympathy is with them, because their plight is a terrible plight. On the other hand, if banks can't foreclose on people who don't pay them back for mortgages, how's a poor person going to get a loan going forward?
Banks aren't crazy. In Brazil, a poor person can get a loan on a car. Get a loan on a car because the courts will allow the lender to repossess the car, but they won't put a family out of their house. So you can't get a mortgage. Yeah.
Would you say that's applicable to the Homeowner Protection Act that's going through the California state legislature right now?
I don't know the details of this act. There's a lot of stupidity in the press about this, stupidity from high positions. It's because there's a phenomenon it's called the difference between an identified and a statistical person. See, suppose that you need money for a kidney machine. The hospital needs money for a kidney machine. It doesn't have a kidney machine, and it needs to do dialysis, and it's very expensive. So what you do is you put an ad in the TV that says, if we don't get money for this kidney machine, some child is going to die this year. Nobody contributes. Then you change it. You change the ad and you say, if we don't get money for a kidney machine, this child here whose picture you see, that child is going to die this year because that child needs dialysis. Then everybody contributes. See, people respond to the identified person much more than to the statistical person. So what happens with foreclosures is that people who are getting kicked out of their houses are identified. And you really feel sorry for them. I can tell you heartbreaking stories from some of my friends who lost their houses. It's just awful. On the other hand, if they don't have to repay their loan, then what about the statistical people who won't be able to get a mortgage in the future? I mean, one of the reasons we got into this position in the beginning was because the Clinton administration pressed the banks to make loans to poor people who had poor prospects of repaying unless prices continued to rise. This should never have been done. Now it's going to be a lot harder for a poor person to get a mortgage. I guarantee you that. So the problem is the difference between the identified person that we can all sympathize with and the statistical person who we don't see. And this is systematic in politics. So the politicians always focus on that identified person, and that leads to distortions in the process. Yes. I'll give you another example of that in the next class, because I'm going to talk about rent control, among other things. All right, so we have this fact that in this class we are mostly going to talk about efficiency and not distribution, because the courts are a very wasteful way to redistribute money, and usually there are public alternatives that are better. So Law and Economics 2 on public law should discuss those matters and not here. Now, how many of you think you want to go to law school? Okay, very good. All right. Now, I want to tell you what this class is good for and what it's not good for. Okay? What this class is good for is you are getting out of this class a lot of the intellectual culture through which the law works and through which it's taught. And this is especially true if you go to an elite law school. If you go to an elite law school, the law and economics that you learn here will come up in your classes. And you will know in an abstract and theoretical way things that your students with whom you're competing, because law school is intensely competitive, don't know. It's a big help. On the other hand, if you go to a low-level law school, and there's nothing wrong with that, if you go to a low-level law school, you're not going to encounter the economic analysis of law. It's not going to be there. Now, why is law and economics an upper elite subject much more than a lower-level meat and potatoes subject in law school? Why is that? Anybody have an idea as to why that might be?
Anybody? Yes.
Maybe lower level law schools are more about practical law, where you can go out and get a job afterwards, whereas elite law schools are more theoretical and thoughtful.
Well, I think I would put it a little differently. I think that the graduates of elite law schools and the graduates of lower level law schools get different kinds of jobs. And the graduates of elite law schools, for them, this is great stuff. Because if you're arguing an appeals case before a judge, if you're arguing before a regulatory commission over a proposed regulation, if you're affecting policies in the state in some way, this kind of stuff is enormously useful. But if you're writing wills, if you're settling automobile accident cases, what I think you have in mind when you say practical, if you do those things, this analysis isn't very good. Because what happens is this. At the lower level, what you need to do is you need to, quote, know the law. And to know the law does not involve very much knowing its consequences. Remember? I told you that what the hole in the intellectual ecology was the lack of a scientific theory to predict the consequences of alternative legal rules. And when you're doing a very practical, relatively low-level practice, you don't have to know the consequences much. What you have to know is what the law is. Okay? If you take the bar exam, you have to know what the law is. At Bolt, we assume at the Berkeley Law School that everybody will pass the bar exam. We don't prepare our students for it. At the end of their third year, they take a bar review course and they take the bar exam, and they almost all pass. Because we're preparing them for something else than the kinds of questions that are on the bar exam. But that's what the night schools are preparing you for, so that you will know the law, pass the bar exam, and be able to do tasks like write wills and civil contracts. Okay, so in the next class, I'm going to do this. The next class, Chapter 2, is a review of economics, and I'm going to spend a little time on that. And Chapter 3 is a review of the law, and I'm going to spend a little time on that, but not much on either. We really get down to the serious stuff in Chapter 4.